Hello, veterans out there. This is the irate veteran coming at you with another video. Any veterans out there that want any veteran to veteran advice, just go to vamadness.com, fill out the contact sheet, and I'll be happy to advise. I would like, before we get started, I want to thank my sponsors. 5 sponsors this year: Sean Kendall, Hill and Potton, the people at VA Disability Group, the people at the Valor Firm, and Wes and Dunn. Let me read this little disclaimer. I am not recommending any specific lawyer or law firm to veterans. Veterans need to conduct their own due diligence before selecting a lawyer or law firm as their representative. That's enough about that. Let's get into our video. Okay, veterans out there, this is a presentation on the Board of Veterans' Appeals, better known as the BVA. There's a lot of mystery surrounding it, so I have brought on one of my sponsors to help me explain, what's what. Sean, why don't you introduce yourself?
Hi, I'm Sean Kendall. I'm an attorney that's been representing veterans for over 30 years, graduated from law school in 1992 and worked as a law student representing veterans as well. So pretty active in this area, representing a lot of veterans in claims before the Board of Veterans' Appeals. Probably the first time I represented a veteran at a hearing in the board was in 1990, in an in-person hearing, and I've been doing it ever since.
Wow, cool. So let's just go ahead and jump right into what happens here when a veteran is going to get into this appeal process. So basically, once we get our decisions, we get this little form with us, which is called the VA Form 20-0998, which explains what our options are. So this is kind of like, if we don't agree with what we see, this is like the VA's way of informing us what to do about it. They don't really give us a lot of information on why we would pick what. So really deciding on what lane to go into sometimes is a little mysterious for us veterans out here. So let's talk about each one of those just a little bit before we get into the actual board process. So here's one of the options, is a supplemental claim. So tell me, when would we use that?
So the supplemental claim, when I talk to my clients about the supplemental claim, it really is an appeal, even though the word appeal is not in the term supplemental claim. Whenever now that you are contesting any denial at any point in history, you have to file a supplemental claim. So if you have a denial over 5 years ago and want to reopen that claim, and the term reopening isn't used anymore, but a lot of people still use that because that's what was under the old system, you need to file this form. If you have a decision within a year, you file this form within a year of a decision, that would be considered a continuation of that old claim and you get the original effective date. If not, then you wouldn't get the effective date. If it's more than a year, it would be the date you file your supplemental claim form. The reason you would file this is you have new evidence, the denial is over a year old, or if you want a quicker decision from the regional office. These decisions, supplemental claims decisions, usually come within less than 6 months, usually 2 to 3 months.
All right, so let's go on to a higher level review. So tell us some about that.
So the big advantage of a higher level review is it's quick. We see those very quickly in our office, usually less than 60 days, sometimes even within a week. The reason that you would file a higher level review is when you get a regional office denial and you want someone else at the VA, not at the Board of Veterans' Appeals in Washington, but someone else locally. Technically, it's not locally. There are 2 special offices that handle most higher level reviews, but another regional office level official to look at the claim again. You're not allowed to file new evidence. So it's based on the record that existed at the time the supplemental claim was denied or the original claim was denied. We find these are very useful in claims where the VA has just gotten a basic thing wrong, like failed to schedule the proper examination, or if a medical examination fails to answer a question that is necessary to decide the claim, like is the asthma related to Gulf War service, some type of question that might be relevant to the claim, and the doctor just overlooked it and the regional office just followed it. So examinations are one of our big reasons. We often hesitate and advise our clients that it could be a waste of your time to file a higher level review if you're really just talking about the overall case case and saying, well, I should be rated at 70% for PTSD. Maybe a case like that would be a good HLR type of review. But the big picture, we usually find that the HLR doesn't make a difference. However, these are so quick, there's no real harm in filing an HLR. We do win a certain number of percentage of cases, maybe 20, 30% of the cases we file at the HLR, we do win that higher rating or service connection. But I think in our office, we don't really view the HLR as a way to get service connection or get a higher rating. We view it as the best way to correct basic errors before having to go to the Board of Veterans' Appeals.
Exactly. So basically, get into facts straight before you go on.
Correct. But, 20% of them are granted. And because they're so fast, those of us that have worked under the old system, if you're a veteran that's filed under the old claim, you're used to the DR review taking 2-3 years. This does not happen. This is very fast. So the risk of filing an HLR is fairly low if the issue you're worried about is delay. Delay becomes a big problem when you file at the board, as we'll talk about.
Okay, cool. So we looked at the higher level review, we looked at the supplemental claim, and now we don't think those are right for us. So when would I actually go to the board with a notice of disagreement?
So the board is much friendlier to veterans than the regional office. That is, claims that have been denied at the regional office are much more likely to be granted at the Board of Veterans' Appeals in Washington, D.C. And that's the primary reason that you want to go, is that you've got a different culture at the board, more experienced, highly trained judges, they're all lawyers. And so the grant rate at the Board of Veterans' Appeals is extremely high. And that's why we would want to go to the board. It's over 50%, especially if you're represented by an attorney. But even representation by a service organization or self-representation, the grant rate is very high.
Yeah, and even the remand rate is another, 30 so percent. Between remands and grants, I mean, it's like 80%. So it's pretty significant, favorable type outcomes at the board. So anyway, when we're actually, when we go to fill out this form, it has a part down here. It's called a specific issue. Can we just call it the issue? Do I need to explain exactly what I mean? What do I think's wrong?
I would advise to be extremely careful and say exactly what you're wrong or what claim you are filing. So as far as a specific issue, that can be tricky because I'm not exactly sure VA knows what it means. Because
exactly.
You're filing a claim for a benefit. So is the issue that I got a bad medical exam in my claim for increased rating for PTSD, or is the issue I want a higher rating for PTSD, or I want a higher rating for my knee disability? So you need to state the claim, and that's usually what we do. That is higher rating for knee, service connection for a meniscus tear, whatever we're actually claiming. It is likely that if you do not say what you're appealing, the board will not address it and you will have to file another claim. And so an example would be if you file a claim for service connection for a back disability and you don't include the sciatica or radiculopathy that is caused by that back disability in your claim, the board is not going to grant that along with service connection for the back. So you need to make sure you filed all your claims. It might be part of a different appeal stream, but if you don't file it, it will usually not be added. And I say usually because the board does all kinds of things. But I would say under the old appeal system, you would find that the board would on occasion add those other issues, and the Court of Veterans Claims has said those issues should be considered part of the appeal. I think with this new system, the VA has put on veterans the burden of being exact about what they want to appeal.
Okay, so, then there's these 3 options, actually kind of like 6 options. Let's talk about each one of those in a little more detail because these options are really important. We have 10A, which is called the direct review. So tell me, when would I pick that versus other ones?
So you would pick this option, 1, for the fastest decision, and 2, because all of the evidence that is needed to prove the claim is in the file. That is, you don't need to testify and you don't need to submit any additional medical opinions or witness statements. So you presented everything to the regional office in your claim, maybe a higher level review, and their VA is just denying it. And so you just want to go to the board and get a decision. And when this new system started in 2019, this was the best lane to be in because we had all our cases set up. We would file and we would get decisions in 3 or 4 months. And through our career, having to wait forever for decisions, it was a fantastic change because veterans that were getting in at the beginning of the system were getting quick decisions. So that doesn't exist anymore. Now there is a significant delay. We're thinking about a year would be typical for a decision. So you don't get an instant decision from the board. So this is a very good appeal lane when you've really developed your case and you don't need to testify in person before a judge.
Right, cool. So, and I have the stats here, the most recent stats, which is through May 2022, which shows, we're at about 330 days to get a case like this decided. So let's go on to 10B, which is evidence submission, which is a little longer, 375. But tell us, when would we look at this as an option?
So one of the changes with the new system and going to the Board of Veterans Appeals is the board is not supposed to be remanding anymore for duty to assist errors. And kind of the classic thing that would happen is that you would present a doctor's opinion that your disability should be service connected. Doctor writes a long report, this back injury is related to parachute jumping in service, has all the reasons. And the board would look at that and say, oh, we want to go get our doctor to comment, see if that's correct. The board can't do that anymore and under any of these 3 lanes, theoretically, and they tend to not. So basically, there's no hamster wheel with going up to the board, getting a remand, going back up to the board, getting a remand, which would take years. The advantage of the evidence review lane, when I get a case and say there's been denial of service connection, is that we get to present the medical evidence. If the regional office has done a poor medical exam or has not done one, theoretically, that's it. The board needs to decide based on that evidence. So that's a real good reason to go into the evidence review.
I completely agree. As a matter of fact, the board's going to make a decision with the evidence on hand. And if they have a very poorly articulated denial from the medical examiner at the regional office, and we submit medical evidence that is definitely adequate, then we're likely to win at the board based on the medical evidence. So now there is, here it says, you could submit your evidence with the appeal or within 90 days. So let's say you decide to submit it with your appeal. Can you waive that 90 days or no matter what, they wait that 90 days?
You can waive the 90 days. We've been asked that, especially when the board was first starting up this system and had the capacity to decide these cases. But realistically, they're not going to decide the case in 90 days. The average time, according to your slide here, is 375 days. And so you can waive that. It probably will not make a difference. I think one of the problems is you can't extend it. And so this is one of the problems you have in choosing this lane is when you choose this lane, make sure you have everything, because if you don't, you're going to have to file a new claim later. And so that is kind of a fairness issue towards veterans, which I think is a little bit ridiculous. There's nothing burdensome to the VA in allowing that deadline to be extended. So I think this is one of the examples of the government being a little heavy-handed and not allowing extensions of that 90 days. And hopefully we'll see some changes to that in the future. The other reason to go in the evidence lane is that it's faster than waiting for a hearing. And so there's a lot of cases where you can get a statement from a veteran or witnesses and submit them at an affidavit. There's a new form that the VA has called the lay witness statement, and get that into the file as a statement to support the claim. So like sleep apnea cases, a statement that says, we observe our friend veteran Joe waking up, choking in the middle of the night, snoring, that kind of thing, rather than waiting for a hearing to testify about that. Spouses can talk about the same thing.
Right.
And so that is a way to short circuit having to wait for a hearing.
Exactly. So let's talk about that. The third lane, which is the hearing lane, which is 500 and some odd days. Just last month, that was almost 700 days. So it did drop some, but it's still talking a year and a half, basically almost twice as long as the direct lane. When would we use this?
Yeah, well, I think that's the number now. But if you file an appeal now, I think it's going to be up. So if you filed your appeal 534 days ago, maybe you're getting a decision now. But I don't think people are getting decisions. I also think this number is inaccurate. we can go into that at some point, but I think VA is manipulating that number because they're expediting a certain number of cases. So you have a big group of cases that is being decided in 90 days, maybe 20%. The rest of the cases are taking long, and so it's pulling the average down. Well, the reality is most veterans are waiting longer. So hearings are important. I mean, this is what lawyers do, is they make presentations before a judge. It is hard to find somebody is lying when they are testifying to you about something that is clearly accurate. I fell in service. I walked across my base in Thailand and I was on the perimeter because that's where we went running. VA turns down claims like that all the time, but when you're in person, it's almost impossible for a judge to say that is not credible testimony. The reason that we go to hearings is because that's where you win cases almost all the time, when we carefully present a case to the board. So that's why I go to hearings. But there are other reasons to go to a hearing as well, is that it allows you to continue to develop the case. If you are in the direct review or the evidence lane, as soon as you submit the case and after that 90-day evidence lane, you just sit and do nothing. And that can be very frustrating for my clients. Like, imagine you have a TDIU claim, you're claiming unemployability, and the issue is, well, I'm only working part-time, and the VA is saying, well, you could work full-time. And then while you're waiting for the board decision, you stop working, or an injury gets much worse, a knee replacement is required. You can't submit that into the file, and so you're going to get a board denial based on evidence that's stale. With a hearing lane, you submit evidence at the hearing. In fact, you're not even allowed to submit it before, which is another terrible, stupid rule. But you submit evidence at the hearing and 90 days after. And so you get the advantage of being able to present personal testimony. You can see what the judge wants. You can ask the judge, is this medical opinion good enough, or do we need to update? Especially in a case like unemployability, do we need updated information?
Would the judge answer a question like that?
They're supposed to, they don't. It depends on the judge. There is a regulation that requires them to do that, which is not followed almost ever. But veterans should. Is this medical opinion good enough? Does it address the issue that I to address?
Yeah, a really important question, because they have 90 days to go out and get another one if it's not.
Right. Or in many cases, you try and prove a claim based on medical articles, treatises that say this type of cancer is probably related to exposure to benzene. And some judges might grant that, but a judge also, or if I get a case late and it's already scheduled for hearing, I haven't represented someone early, going to the hearing and being able to say, okay, the articles aren't good enough, we're going to need to go hire an expert.
Right. So let's get into a little more detail. Now, once you get a decision from a board, it looks something like this, right? It'll have your name and, the board's stuff on it and the order and what they're doing, and then facts about the case. But with it will come VA Form 4597, which basically gives you your options, what to do with a decision once you get it. So I did notice on this form, it still talks about new and material evidence as if, that still applies. It certainly does under the old system, but on the new system, it's new and relevant evidence, right?
This is correct, yes.
So this form is like a little out of date. It's only been 3 years. I'm sure they will catch up. So they're, depending on what your decision says and whether you agree with it, you still have options then.
There is an updated form actually that explains the options.
Is there? I got this right from the board's website.
Okay, we'll have to. We should look for that. Put a link in to that.
Yeah,
because I've seen a different form, and actually the options here are quite different than what is here, because the main option that is not listed in this particular form is that you have 1 year to submit a supplemental claim in response to the board decision. So if the board denies your claim and says, look, you haven't presented any evidence that you were choking or having sleep problems in service, so we're denying your claim. You can go back to the regional office, file a supplemental claim with that evidence, such as a spouse statement, and the effective date is preserved. In the old days, you had to start over and you would lose the effective date, not get those back benefits. Under the new system, you can file a supplemental claim in response to either a board or even a court decision with new evidence. So for example, we've had both the board and the court say in cases, well, the vocational opinion doesn't really support that this veteran can't work in the market. And we just start over with a new vocational opinion and often can win that way. So that's the main difference that's not highlighted in this form. So we really probably need to emphasize that there's other other things that you can do.
Right. And that's why I made the little note here about file a supplemental claim, because that's kind of what it should say, and it doesn't. So, but now, great, we covered that. Now, there's things that can happen at the board. Basically, grants and remands are what I consider positive outcomes. Tell us some about what, like a grant, what happens when you get something granted?
Well, so if something is granted for service connection, you still have to decide what rating is going to be assigned. And so that is not assigned at the Board of Veterans Appeals. It's assigned at the regional office, and you still have to assign the effective date. So unfortunately, the case isn't over. And especially if you've been waiting 3 years for a decision after a hearing to get service connection and then have the VA assign a low rating, that could be very frustrating. But often it also can work out well. That is, you get the correct rating assigned and the correct effective date. So it always does return to the agency of original jurisdiction for action. Now, the agency of original jurisdiction is a term that, as a veteran, you probably do not need to know. But what basically happens is the VA now has a special office that implements board decisions. So if you're from Denver and case goes to the board and is granted, it's not the Denver office that will assign the rating. It is this special office. AMC was a name for it at one time. I think they're calling it DROC DC. Again, the name really doesn't matter because it keeps changing. And the reason the VA did this is for the last several years, getting those grants and remands implemented was taking a very long time. Now, in most cases, it is going pretty quickly. However, there is a small group of cases that for some unknown reason is not being handled by this special office, but is just being handled by the regional office in the normal course of business. And those are being delayed significantly just because of regional office mismanagement and incompetence.
Right. So on a remand, tell me about that.
Same thing. Most remands are being handled by a special office. They're not actually going back to your local VA. So the local office is scheduling the medical exams. Most remands are for either to get additional evidence, such as Social Security records or a doctor's notes, or for a new medical exam. And so again, the VA should be commended for when the cases in the 96, 95% of the cases that go to this special office, they're being handled very quickly. Remands prior to appeals reform or an old legacy case were just an invitation for massive delay. Would usually take 1 or 2 years to handle. Now we find most actions that are ordered by the board on remand will happen within 60 days.
Wow, great. Now, when I get a grant or remand, like a grant, for example, where if they have any other questions, or on a remand specifically, will I have any opportunity as a veteran at that point to submit any new evidence?
So on remand, it's actually classified as a supplemental claim by the regional office in their computer system. They call it remand supplemental claim. You can submit evidence, but they don't tell you that. So if the case is remanded, the record is open for you to submit evidence, but you need to.
Yeah, so there's no official notification. If I think I have some current relevant evidence, it's time to submit it once it's remanded.
That's correct.
Okay, cool. And they will then look at the whole record at that time when they make their new decision.
That is correct.
Now, let's say it's remanded and the regional office still finds negatively. Will they then send it back to the board, or will they send you a new decision that you have to take action from?
It's a new decision and you have to take action. So remands are fairly low in the new system because the idea is to avoid remands, because that was why there was so much delay before, but there still are remands. But it is a decision that has to be appealed again. The disadvantage is you don't get your place back in line. You start all over. In the old system, when they remanded it, your case was considered to be in the same docket order. So remands would be decided before new cases, theoretically. But now you start all over from the beginning. And this can be a big problem for a veteran if you've waited 3 years for a hearing, you get a remand, you get a decision, and now you've got to go back to the board. If you have to submit evidence in response, you're in the evidence lane. And although your stats showed 355 days for the evidence lane, and it's probably more going to be 2 years for veterans that are appealing now. So this remands are going to result in big delays unless you can get it granted at the regional office. And it might be better to also, instead of going back to the board, if you get a denial after a remand, you have the opportunity to do a supplemental claim, and you have the opportunity to do a higher level review. In a lot of those cases where we don't get a grant after remand in the AMA system,
So if you get denied again and you end up back at the board, your effective date doesn't stay intact?
Your effective date for your benefits stays intact.
Okay, good.
But your docket order doesn't.
So you're at the back of the
looking
line.
at big delays.
Yeah, I get exactly. You might have, if you choose a hearing lane again, another couple of years, so, or year and a half anyway. And like you said, the line will probably grow, right?
Yeah.
So the decision itself, one of the things I noticed with a lot of board decisions is that on the same set of facts, one judge might determine one thing and another judge may determine another thing, especially on pyramiding, to where one judge might allow certain things and some judges won't. So can the regional office correct it if they don't agree that the pyramiding rule was applied properly?
So the regional office cannot. You're definitely going to see this happening, but the law is that the favorable findings, not only of the board, but also of the regional office, which can be a real tool for winning a case, is if the regional office makes a favorable finding and you go to the board judge can't overturn that either. So you were exposed to Agent Orange in service in Thailand, board can't reconsider that. So that can really be used favorably. And also the other way, the regional office cannot reconsider that. So, I have a case now where the board found there was a favorable diagnosis of a complex disability that exposure to chemicals caused. The regional office got a medical opinion that said she doesn't have this disability. And the regional office recognized, well, that's not the question. The disability.
Right. So they basically were kind of bound regardless of what their doctor opinion opined. So
this is a very favorable rule to veterans. And so people really need to take advantage of it and argue what the favorable findings are in their decision.
Okay, cool. So basically what you get from the board, you could pretty much count on, especially if it's a favorable grant. You can count on that sticking, right? The government itself isn't going to challenge their own judge's opinion.
Correct.
All right, so let's talk about negative outcomes. All right, let's say you're at the board and they don't agree with anything you put forth. What happens then? It looks like there's a couple of options that are listed on the 4597, which is a reconsideration or an appeal to the Court of Appeals for Veterans Claims. So tell me about those options.
So, and again, supplemental claim, don't forget that. That's something. So BVA reconsideration is generally a waste of time unless you have an attorney or highly trained service rep tell you that there's an error of law. The best reason to file a reconsideration is that you need more time to consider the appeal to court, because it does stop the 120-day
so it does stop the clock. That's great.
But the standard for getting reconsideration is very high. Now, also listed is the motion to vacate to the Board of Veterans Appeals. There's no time limit on that. That is not an error of fact in law. And by error of fact, we don't mean you didn't decide in my favor. You didn't agree with what I argued. It means something that is factually completely wrong. That is, we have cases where the board says you weren't married. There's a marriage certificate in there. That would be a potential motion for reconsideration. Motion to vacate is where it's a simpler error. My colleague can probably comment on this in a future video, when to do a motion to vacate. But say there's missing records. The board says, we're remanding this to get records. They're in the file. You can file a motion to vacate and the board will likely grant it. Motion to vacate does not toll 120 timelines. So a slide here doesn't have that, but it is in the notice, and it is something to talk to a service rep or an attorney about as a quicker way to get relief from a negative board decision. The Court of Veterans Claims is your other option. It's 120 days to file a notice of appeal. You can file it on your own. Usually there are attorneys that offer services to veterans that have filed without an attorney. A bunch of letters arrive in your mailbox. VSOs and agents are not like licensed to represent in court. The court has kind of cracked down on non-lawyers working there, but it is possible to get representation as to get accreditation to work at the Veterans Court as a non-lawyer, but mostly it's a practice reserved for lawyers. Most lawyers will not charge a fee at the court because if you win, attorney fees are paid by the government. So there's an incentive for attorneys to do that work for veterans without directly charging the veteran. And that money does not come out of benefits.
Wow, so that is really good. When I was got my case, one of my cases denied at the board, and I was considering an appeal to the federal court. As soon as I looked at all the court rules, that convinced me like almost immediately to act on one of those advertisements I got from the lawyers who were seeking to represent me at the, I did file the initial notice with the court, and that's when I started getting those letters. But I mean, I believe I'm competent to explain, veteran issues, but when it comes to the court rules, I mean, I was completely confused. I know myself, veterans out there, if you're going to the court, my advice is don't even attempt to do it yourself.
Sure.
So, but anyway, let's talk about the reconsideration. We did talk about that a little bit just now. Is there a required format?
No, the board has actually interpreted just one sentence letters as being motions for reconsideration. So a letter, I want reconsideration of this decision, it's wrong, is probably a motion for reconsideration. And in a case like that, it will stay the 120 days to file your appeal. That is, you don't have to file your appeal in court until the board decides your motion. And in fact, if you do both, the court will dismiss your claim or stay the case until the board decides the motion.
So in this, will the same judge look at it, or is it
No,
panel or?
No, only usually one of the vice chairmen will look at the case and decide it. I have not seen one of these granted in years. It's a complete waste of time.
All right, good. So
motion to vacate is
the option.
Better option.
So, but yeah, so, and then, so there's instructions here where to send it and whatnot. And then to appeal to the court, there's some specifics. You got the 120-day thing going on. And then, of course, it has the court's address in here. I mean, is there anything else you'd want to say about that as far as what you would need to do to start the process? And
so
when would you get a lawyer involved?
Make sure the court is getting it. So you want to have evidence that you filed in time. The board does use a mailbox rule. So if it arrives a few days after, there's an assumption that it's been filed, but you don't want to rely on that. You want to either send it by certified mail or overnight mail, or what we file is by fax or even email. I think on the updated form, there's an email address. There is on the court's website. You can file an appeal by email. There is a court form, but for a pro se veteran, that is someone who's representing themselves, you can send in anything that indicates your intent to file. You probably should put the date of the decision that you're filing. You do not need to say what the appeal is. You talked about the court rules. You're just filing a notice that you want to appeal. You'll have a chance later to offer the reasons. If you're doing this on your own, there is a simplified rule procedure at the court which allows you to file basically a questionnaire that the court has explaining why the decision is incorrect. And pro se veterans do win their cases all the time. So it's not a possibility.
My thought always is, especially when it comes to, do I represent myself before the court, is a lawyer here is going to be free. Why wouldn't I use one? To me, I want to tap that expertise. But in any event, so there is some consideration for pro se veterans, which is good. So let's say I decided I was going to go with a representative, a lawyer. Would I contact them right away, or do I need to submit the notice of appeal to the court first, or does a lawyer help me with that?
I think you need, the internet, you can Google and find lawyers that are representing in court. I would prefer to get cases before they're filed, although the deadline is always a problem. I want to make sure that I've got more than 30 days before the appeal is due to actually review the board decision. But again, after you file the appeal, there is really a period of 2 or 3 months before anything actually happens. Your case sits there as the government has to prepare the record on appeal, which is a copy of your claims file that is page numbered for reference for the judges. But yeah, looking at a veteran's case and deciding whether I want to appeal it, I usually need the board decision. talk with someone on the phone for a bit, whether I actually need to review the evidence or not, that would be something that's the case. But I usually have a pretty good sense. I've been doing this for so long of what the VA errors are. And I think most attorneys that practice in this area do.
Right.
There's all kinds of law firms that do this, from small firms like us. We've got 3 attorneys to there's a couple of law firms that are probably more than 50 attorneys that do this kind of work.
Yeah. So big thing here, veterans, don't procrastinate. Right.
Yeah.
So kind of here's the conclusion with a court decision that I had on one of my cases. And one of these cases was vacated and remanded. So what happens then if it goes to the court and they send it back to the board then on a vacated decision?
So this is going to be a big issue, because when you had your case under the old system, the rules were different. And under the new system with filing appeals, there's going to be some big problems with getting new evidence into the file. So under your case, when the case was remanded back to the Board of Veterans' Appeals, the board would give you notice and you had an automatic right to submit new evidence into the case file. Under the AMA, there is no right to submit anything new in response to a court remand. The record is closed, because if you think about the 3 lanes you are filing in, the record is either closed immediately or 90 days after you file the notice of disagreement in the evidence lane, or 90 days after the hearing. And so after a court remand, there's no basis to submit anything new. So this really changes the kind of appeals that are going to go to court, because a lot of times you want to go to court and you want to respond to something. That is, all the VA doctors say heart disease is not caused by PTSD, and you're arguing, well, they didn't make a rational conclusion. There was all these medical articles that say heart disease is caused by PTSD, and the court remands to further discuss it. They ignored one of the medical articles. The record's closed. The board is only going to respond to the court decision. They could respond to argument. The board actually invites you to submit additional argument, but you have no ability to submit additional evidence. If you want to submit additional evidence, you have to go to the supplemental claim lane. And so there's going to be a certain class of cases in the future where you could get a favorable decision, a remand, but you're going to end up filing a supplemental claim because you needed to get something new into the case. Now, from a practical point of view, if time is not an issue, because you don't lose the effective date, because every time you file a supplemental claim within the year of a court decision, even a remand, you get the original effective date.
Yeah,
and
so
the advantage is wasting time.
So technically speaking, as far as keeping your effective date intact, I mean, a supplemental claim is a reasonable way to get new evidence in, and maybe even save time.
Right. So there's a lot of veterans. So if the error you're appealing to court is the VA failed to get records, why wouldn't you just go get those records yourself and file a supplemental claim?
Oh, exactly.
And so there's going to be a certain class of cases where I think a lot of people, lawyers and veterans, are going to be frustrated because they're going to get a favorable decision from the court, but they're going to end up having to file a supplemental claim anyway. And so there's the question of, instead of responding to the board decision by going to court, should you just go back to the regional office? So we have a claim where we were denied at the board, service connection for PTSD. The board did not agree with our expert report, made some conclusions about the veteran's history, which we didn't agree with. We could have won at the court. That is, at the court would have said, you didn't provide good reasons for not believing the veteran. But all we would have gotten was a remand for the board to provide more reasons. Instead, we started at the supplemental claim with another expert report, the veteran's response to those reasons. I mean, basically saying the veteran had 2 stressors. One stressor involved combat, and the board said, well, the doctors you never talked about your combat experience with your doctors. And that was not true. We could have won in court, but instead we went back and submitted new medical evidence from that doctor that says, of course, combat is one of the stressors. Here's all the times we talk about it. This is why it is. And so we kind of cut the court out of the decision, or out of that process. Maybe eventually we'll have to go back to court, but we'll have, what we think is a record that
and a better case going forward.
Yeah. I mean, to some extent, we didn't expect that to be the reason. we said not only do we have these non-combat stressors, we have combat stressors, we have hearing testimony, what's the problem? And so some of the judges would have granted that claim. I thought it was a pretty solid case. The board came up with reasons going to court was not a good option.
Yeah, definitely. There's a lot of inconsistency with how you expect things to happen, especially in line with facts. So what I found, kind of like anything can happen at the board, right? No matter how great your case is, you still may lose. And sometimes without even that great of a case, you may win, so it's a crapshoot, but like we've already discussed, it's a reasonable one if you have a case backed with decent evidence. So I wanted to kind of show this little flow chart of all the decisions and options that there are in the whole process. And, everything does go back to a supplemental claim. At each point, you can choose that. But there's a lot of options here. It's a complicated process. If you don't understand it, definitely talk to a VSO, talk to a lawyer, get out there and don't try to wing this. It's a bad idea. So we kind of covered everything I wanted to talk about. Do you have anything else you want to say on the topic?
Well, one of the things is, so I would like to see in the comments about people filing appeals to the board. And I guess there's the thing I worry about is people filing those appeals with the regional office, because technically you're not supposed to do that. As most of us know, you now mail things to the regional office by mailing them to Janesville or faxing them in. But I would like to hear about people using the VA's direct upload tool, which I guess is changing again. So there is an option to upload appeals to the board directly. If you filed an appeal, you don't want to wait to the last minute if possible, but you should get an acknowledgement letter from the Board of Veterans Appeals saying what lane your case is in, and then if you're in the evidence or hearing lane, what your deadline is for submitting evidence in the case. So obviously the evidence lane is the lane where the deadline is ticking even before getting that letter. So you want to keep track of that 90 days. But yeah, getting that appeal filed with the right place, that is the Board of Veterans Appeals, either using their fax number, mailing it directly to the board, or best way now is using the VA's direct upload tool.
Definitely the direct upload, I think, is the way to go. I've had several veterans recently, by the way, mail things directly to the board's address, and they put trackers on their mail, and it was actually delivered to the board and then rerouted from the board to Janesville. So it looks like even if you send it to the board, it's going to end up at Janesville anyway. I find that weird. Why send it to the board if they're going to reroute it to Janesville?
Yeah, and I don't know how it would be received at the board.
Exactly.
I think the reality is, unless you can't avoid it, use an electronic tool, a fax with a response that shows that it was received, but even preferably now the direct upload tool. Everything
definitely check.
They use direct upload.
I haven't seen the direct upload directly to the board, but they do have the quick submit option on Access VA to where you can submit things directly to Janesville with no problem. So there are options to get things to Janesville. My question is, did it get to the board? So that direct upload to the board would be a big deal. I haven't checked it out yet, but
yeah, it exists for attorneys. We have a different tool as accredited representatives or attorneys. We've got a different tool which does specifically say board. So this is the first I've heard that veterans do not have that opportunity. Yeah, so I'd worry about it getting to the board.
And not just that. Once I had one of the veterans, again, fairly recently, that sent everything to the board, and it was getting close to his year time frame, and he had never got any type of confirmation that they received anything, including on va.gov. So I told him, I said, listen, you've got like 2 weeks left and you don't know it's at the board. I would resubmit it. And when he did, then he got acknowledgement to the recent submission, but they've never acknowledged the old submission whatsoever. And now he's on the docket per the new information or for the new submission. So I don't know what happened to the old submission, but like I said, veterans, it's best never to wait to the last minute, because you may have that question. Does the board have it? If you've never received any type of confirmation on va.gov, then you should think about maybe resubmitting that information. But anyway, anything else you want to say?
No, I think we've been pretty thorough.
I think so. So say goodbye, Sean.
All right. Thanks, Eugene.
You're welcome, and bye-bye. Irate Veteran, out.